that they try to care about. The children that really need their help don't get any, right? They don't get any.
Everyone who hates ads will be using this Chrome extension by 2025. I feel like I just found a Google cheat code. It's a Chrome extension called...
These kids are going through hellacious abuse in every form and way you could think of. And Child Protective Services don't care, right? They don't care. They don't care about the kids they should, right? It's the ones they shouldn't that they try to care about. The children that really need their help don't get any, right? They don't get any.
Yep.
I had that feeling as well. Absolutely. I had that feeling as well.
I pray and hope she never gets her kids back. I'm sorry. Those kids need to be in a loving environment with people that actually will sit there and take the time out and love and care for them.
Right. The oldest son was the one that was being a problem. It wasn't the younger two that was a problem. It was the oldest boy. The oldest boy was constantly attacking the other children. From what I've seen in videos and so forth, it's the oldest boy.
Very mouthy little boy too.
Yeah. He was learning to be hands-on like Grandis and Donald, right?
Yeah.
Did you ever see Donald discipline the kids very often, Allie?
He yelled and he would threaten them, but when I was there, he wasn't really ever home except for at nighttime when he was done working.
So you never see him lay hands on them?
He might have smacked him once or twice in front of me.
And was he like Candace? Was he like wherever it landed, or was he?
Oh yeah.
Same way, huh? So Don Wells, just as brutal as Candace was. They both was brutal, and probably Grandis too. Probably Grandis as well. Wow.
Yep.
Yeah. So it might be best they don't return to that environment, right?
Yep. I had someone ask me today how I discipline my kids. I said, I'm very strict. I take their electronics away and I ground them. I will not put my hands on my kids. If you don't want to help do your chores and you're not getting your electronics, I'll take them away.
Absolutely. I think that children, I agree, Molly, children are, they are little humans, and they, I agree. You could tell Allison did not really discipline her kids in any form. She did not discipline her children in any form. Allison just kind of just, go with the flow, right? She was a go with the flow mom. What I'm talking about is, she worked and she, it's like, she was just living and let live, right? If you guys get out and get in trouble, that's on you. Whatever, it's on you. I don't care, it's on you type parent. And these kids were just buck wild, right? They were just freaking buck ass wild, running, doing whatever they pleased. And Allison, she didn't know how important it was. She did not know how important it was, right? To not really discipline, but to educate, right? If you educate your children, you don't have to discipline them. And that education starts, that education starts right out of the womb, right? Right out of the womb. You need to start educating your children. What I'm saying is, you got to spend time. You got to spend time, singing little songs and singing little nursery rhymes and doing the 1, 2, 3 ABCs. You got to start way early on, right? Letting your children listen to, the better music in the world, right?
Hey, sorry guys. I had to get my coffee. My husband's off today. We roll cigarettes, so I had to get them in my pack. I had to all kinds of shit. Water, go to the bathroom. All right, so this is my plan. I've already played about 5 minutes of this. I want to go through about 15 minutes of this. Running Bear said hi, Earl. He can't hear. I'll tell him when he comes in. I am a coffee addict. It's so bad. I drink a lot of coffee. I do. I need to slow down on it because it's not good for my heart. Although my heart beats slow, so sometimes I feel it helps, but sometimes I have too much. I used to be on this medicine, digoxin, that made my heart beat fast. They took me off of it because it's dangerous. You are too. Okay, I'm going to let you guys pick. I have 2 things, but let me tell you, when I get to page like 34, I got really confused because my daughter came down and wouldn't shut the fuck up. She was in the back of my ear like yap, 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 yap. So I had to stop what I was doing and I got confused. But I took that document from that court thing earlier. I'll have to scroll, and this is 98 minutes long. That's what the 40, it was actually 44 pages because ChatGPT said the last 2 pages were the same, but it didn't look the same to me. So there may be some errors after page 34. But you guys will get the gist of that case with Ajon, Bowers, and Simpson. And we can get through more than 6 pages. However, I really don't feel like scrolling. I can download it, put something pretty on the screen, or y'all could just listen. I prefer if we all just listen because that would take some time, but at least get through a little bit of it and then we'll take a break and then we'll come back to PG for a little bit. I don't know how long this is going to take or how far we're going to get. We'll see when you guys start to get bored with the court documents. If you get bored, if you do, I'll move on. If you don't, fuck it. We'll go, you know what I mean. Okay, so let's go over to Play HT. I'll scroll a little bit. I hate doing that. It's such a pain in the ass. I should have just, you know what, let me see. Let's see how long it'll take to export as a single file. Let's see if it's going to take forever. I was trying to get on and I was putting this together. I told you guys I'd be back in a couple hours, but yeah, that never happens. I'm never on freaking time. Okay, see, this is going to take a long time to export. So what we'll do is I'll let it export. We'll let it play. Hopefully it doesn't stop. I may have to refresh the page. No, we ain't even going to do that. We'll figure it out as we go. Okay. Jesus. Take the wheel. All right. Let's put the timeline up. It's still loading. Give it a second. I stopped the export. Yeah, that's what I'm saying. It's so small. And everybody just says to me, I can't see that. I can't see that. And it turns into stress. So that's why I figured I wish I could just put it on a nice screen, but it's going to take me a long time to export it. I wish I would have exported it before I came live. So we'll just listen. It's still loading. Give it a second. But you know what? While that's loading, we'll go back to, because I want to get through a little bit of Prayer Garden tonight. But we'll just listen to this part. This is, you know, they're going to go on and on about abuse with the wills. I'm not going to address this part tonight. You guys are welcome to address it in the chat. I may just ignore it. Just make sure you put your opinion. I'm not ready to talk about this part. I don't like this. And if it's true, I like it less. If it's not true, I'm sorry this is being done. But in my opinion, this is the shit that should have never came to YouTube. It should have stayed with the TBI and feds. Okay.
You got to read those little Bible stories to your children. You got to teach them about, you know, why they're truly here and what the whole purpose is, you know, at the.
However, this part was touching. It's just a little section of it. I agree with Prayer Garden that you should do these things when your children are young. I absolutely agree with that. I'm not saying you shouldn't. It's the hypocritical shit she says after it, before it, and between it. It's the put downs and the downing a dead lady, you know? And I'll be with you guys in chat in just a minute. I'm going to check on this and, you know.
The end of all of this. You have to educate them. And if you educate them as, you know, as they grow up.
This is the fastest way to get rid of neuropathy. If you have neuropathy, pay close attention.
Then, you won't have to discipline them because they'll be good kids. But you have to be, you have to be educated as well. You have to be willing to go that extra mile, to not only keep your own children safe and teach them to keep themselves safe, but also to keep other people safe as well.
United States District Court for the Eastern District of Tennessee A.T. Greenville. Alan Mark Ajan. Petitioner. NO 202 CRA 71. NO 206 Sieve 24. Judge Greer. V. United States of America. Respondent. Memorandum Opinion. On January 30th, 2006, Alan Mark Ajan, petitioner or Ajan, a federal prisoner, filed a petition under 28 U.S.C. SS 2255 to vacate said aside or correct sentence by a person in federal custody. Doc. 273. Attached to the petition was a letter in which petitioner sought additional time within which to file a memorandum in support of his petition. Doc. 2731. On March 3, 2006, Ajan filed a motion to amend SS 2255 pursuant to Rule 12 of Rules Governing SS 2255 Cases in Fed. R. Ciev, P. 15a, and a 32-page brief in support. The government filed its opposition to the petition on October 17, 2007, Doc. 310, and the petitioner filed a motion to supplement SS 2255 motion, along with 2 supporting affidavits, on October 22, 2007. Doc. 273. On February 6, 2008, Ajan filed a 54-page reply to the government's response, Doc. 324. And on April 23, 2009, Ajan filed a second motion to supplement his SS 2255 petition, Doc. 336. The matter is now ripe for disposition. The court has determined that the files and records in the case conclusively establish that the petitioner is not entitled to relief under SS 2255 as to all issues raised by him, except for the issue he raises pursuant to United States v. Combs, 369 F.3d 925, 6th Sir. 2004, on which the court will receive further briefing as discussed below. The record likewise establishes that no evidentiary hearing is necessary, and Ajan's request for an evidentiary hearing will be denied. However, counsel will be appointed to represent Ajan on this issue raised under Combs. The court will therefore dispose of all issues raised by Ajan, save the one.
I also forgot, there's a new Wade Wilson video that came out. I listened to a lot of it, not all of it. Earl's off tonight, and he's going to do a reaction. I cannot wait to see his reaction to this next video. I'm just deciding, I don't think Jumpsuit did it yet. I don't know. He might have. I'm just going to show it from phone calls from prison. Okay. We'll do that after everything so we can have a calm down.
Raised pursuant to Combs, and, for the reasons which follow, the petitioner's SS 2255 motion lacks merit, and the motion will be denied in its entirety, except for the single issue raised under Combs. In addition, Ajan's April 23, 2009, motion to supplement will be denied. Procedural background. Ajan was indicted by the federal grand jury on July 23, 2002, along with co-defendants George H. Simpson and John Vance Bowers. Ajan was charged in Count 1 with conspiracy to distribute and possess with the intent to distribute 5 grams or more of methamphetamine, in Count 2 with conspiracy to distribute and possess with the intent to distribute a quantity of methamphetamine, lesser included offense of Count 1, in Count 3 with possession with the intent to distribute 5 grams or more of methamphetamine, In count 4, with possession with the intent to distribute a quantity of methamphetamine, a lesser included offense of count 3. In count 6, with distribution of a quantity of a mixture in substance containing a detectable amount of methamphetamine. In count 8, with brandishing a firearm during and in relation to a drug trafficking offense. In count 9, with conspiracy to commit kidnapping. And in count 10, with aiding and abetting kidnapping. And in count 10, with aiding and abetting possession of a firearm in furtherance of kidnapping, a crime of violence. Doc. 1. On December 19, 2002, a jury found the defendant guilty of counts 1, 3, 6, 7, 9, and 10 and not guilty as to count 8. Doc. 157. On April 28, 2003, Agin was sentenced to terms of imprisonment of 262 months, the bottom of the guidelines range, on the drug and kidnapping offenses, to run concurrently, and a statutory mandatory consecutive 384 months on the SS 924 C convictions, counts 7 and 10, for a total sentence of 646 months imprisonment. Doc. 220. Agin's convictions and sentence were affirmed on direct appeal by the Sixth Circuit Court of Appeals on December 15, 2004. United States v. Simpson 116F Appiex 736 6th Sir. 2004. Petitioner then filed a petition for writ of certiorari in the United States Supreme Court, which the court denied on January 24, 2005. Agin v. United States 543 U.S. 1129, 2005. Petitioner's pro se petition for rehearing was denied by the Supreme Court on March 21, 2005. Agin v. United States 544 U.S. 945, 2005. Petitioner's SS 2255 petition was timely filed on January 30, 2006. I. Factual background. The following statement of facts is taken from the government's brief. The trial evidence is summarized in part in the Court of Appeals decision. See Simpson, 116F. Appiex at 73839. The United States presented the testimony of 22 witnesses to establish petitioner's guilt beyond a reasonable doubt. Eric Alford, an officer with the Kingsport, Tennessee Police Department, testified that he stopped petitioner for suspected drunk driving on November 26, 2000, and as a result, petitioner was arrested. A search of petitioner's vehicle incident to his arrest resulted in the seizure of a quantity of white powder in a cigarette pack, digital scales, and a box of baggies. Alfred also found a cell phone in the vehicle and called the last number dialed, reaching co-defendant George Simpson. Without identifying himself, Alfred told Simpson that petitioner Agin had passed out and needed help. Simpson responded that petitioner was his boss and told Alfred to bring petitioner to the Coastal Mart on Bloomingdale where Simpson would meet him. Kingsport officer Mike Hickman was dispatched to the market to meet Simpson. Id. C. Simpson, 116F. Appiex at 738. The white powder found in petitioner's car was analyzed by an employee with the Tennessee Bureau of Investigation Crime Laboratory, who testified that it was 22.2 grams of methamphetamine. DA Special Agent Mike Stedman testified that, in his opinion, a person simultaneously possessing 22.2 grams of methamphetamine, plastic baggies, and digital scales would be engaged in the distribution of methamphetamine. On cross-examination, Stedman calculated that 22 grams of 22% pure methamphetamine would produce 800 dosage units. Returning to the events of November 26, 2000, Officer Hickman responded to the Coastal Mart at around 10 p.m. to meet Simpson. In due course, Hickman observed two men wearing camouflage coveralls and bulletproof vests and carrying binoculars and two-way radios. Hickman engaged them in conversation, asked for identification, and one man identified himself as George Simpson. Hickman asked the two men for permission to pat them down, to which they consented. Hickman retrieved a loaded .38 revolver from Simpson. I'd. At 24-30, see Simpson, 116F. Appiex at 738. 2 weeks later, on December 8, 2000, Curtis McDavid, Ernest Lynn White, and Ricky Howe met at the Hog Wild Saloon, a bar across the street from the West Side Motel in Kingsport, Tennessee, where White had rented a room for the night. After the bar closed, the three men went to White's motel room to drink a few beers. At about 2:30 a.m., McDavid and Howe left to wait for a taxi, but when it did not come, they returned to the room, entering through the sliding glass door. R. 184, Trial TR, Curtis McDavid, at 74 to 78, 87, 91 to 92, R. 185, Trial TR, Ernest White, at 2 to 12. Ricky Howe, at 71 to 75, C. Simpson, 116F. Appy X at 738. While the three men were in White's room, George Simpson, petitioner agent, and John Bowers forced their way into White's room, brandishing firearms. Simpson forced Howe onto the floor, placed a gun to his head, and demanded that Howe identify himself. At the same time, McDavid was thrown onto the bed by one of the intruders, who repeatedly struck him in the back of the head with the butt of a firearm and tied his hands behind his back. White's hands were also bound, and he was forced to the floor. The intruders blindfolded White and took him from the room. As the intruders left with White, they instructed Howe and McDavid not to leave the room. The two men complied, but eventually freed themselves and left the room, where they flagged down police officers. R. 184, Trial TR, Curtis McDavid at 74 to 78, 87, 91 to 92, R. 185, Trial TR, Ernest White at 2 to 12. Ricky Howe at 71 to 75, C. Simpson, 116F. Appy X at 738. Officer Mike Hickman of the Kingsport Police Department was called to the scene of the kidnapping. At around 4:30 a.m., Hickman and other officers found White at a gas station, bound with duct tape but alive. White informed the officers that he had been taken to a remote area where the intruders demanded money from him. He further stated that the men released him after several hours but left him bound with duct tape in the middle of a field. Hickman found a cigarette lighter and white rope at the location where White had been held. The officers also found tire tracks leading to and from the scene. R. 184, Trial TR Mike Hickman, at 24 to 30, Ernest White at 2 to 12, C. Simpson, 116F. Appy X at 738. After Simpson's arrest, an extensive investigation of the events surrounding the kidnapping took place. As part of the investigation, DEA Special Agent Stedman analyzed the evidence found in White's motel room and in Ajon's car. Stedman's testimony confirmed the forensic analysis, noting that the methamphetamine found in Ajon's possession was sufficient for distribution. Additional evidence was collected from the other suspects involved, further tying them to the conspiracy. All of the evidence pointed to the group's involvement in a broader drug distribution and kidnapping scheme. R. 207, Trial TR, Jacob White at 38 to 41, Mike Stedman at 2 to 9. White further testified that after his release, he received a phone call from George Simpson instructing him not to talk to the police. Simpson told White that he would be sorry if he did not follow his instructions. White identified Simpson, Ajon, and Bowers as the individuals who had kidnapped him and taken him to the field. R. 184, Trial TR, Ernest White at 2 to 12, C. Simpson, 116F. Appy X at 738. Ricky Howe and Curtis McDavid also testified, corroborating White's version of events and identifying the same individuals as the perpetrators. R. 184, Trial TR, Curtis McDavid at 74 to 78, 87, 91 to 92, Ricky Howe at 71 to 75. In addition to the testimony of White, Howe, and McDavid, the government presented the testimony of several law enforcement officers who were involved in the investigation of the events leading to Ajon's arrest. Officers testified that during a search of Ajon's vehicle, they found multiple firearms, including a .38 caliber revolver, ammunition, and other materials commonly associated with drug trafficking. The officers further testified that Ajon had a prior felony drug conviction, which qualified him as a career offender under the United States sentencing guidelines. This prior conviction significantly enhanced Ajon's sentencing range, resulting in the mandatory minimum consecutive sentence on the firearm-related charges. R. 184, Trial TR, Mike Hickman at 24 to 30, Jacob White at 38 to 41, Mike Stedman at 2 to 9. Ajon's sentencing occurred on April 28, 2003. Based on the guidelines, The court sentenced Agent to 262 months of imprisonment for the drug and kidnapping offenses, followed by a mandatory consecutive sentence of 384 months for the firearms convictions. In total, Agent received 646 months of imprisonment. Agent's co-defendants, George Simpson and John Bowers, received similar sentences based on their respective involvement in the drug distribution and kidnapping scheme. R. 220, Agent's convictions and sentence were affirmed by the Sixth Circuit Court of Appeals on December 15, 2004, and his subsequent petitions to the Supreme Court were denied. R. 184, Trial Tr. Curtis McDavid at 74 to 78, 87, 91 to 92, United States v. Simpson, 116F. App X736, 6th Sir, 2004. Following his unsuccessful appeals, Agent filed this petition under 28 U.S.C. SS 2255, seeking relief from his conviction and sentence. Analysis of claims. Agent raises several claims in his SS 2255 petition, each of which the court will address in turn. A. Ineffective assistance of counsel. Agent first claims that he received ineffective assistance of counsel at both the trial and appellate levels. To prevail on this claim, Agent must demonstrate 1. That his counsel's performance was deficient, meaning it fell below an objective standard of reasonableness, and 2. That this deficient performance prejudiced his defense, meaning that there is a reasonable probability that the outcome of the proceedings would have been different but for counsel's errors. See Strickland v. Washington, 466 U.S. 668, 687, 1984. Agent alleges that his trial counsel failed to adequately investigate and present mitigating evidence during sentencing, failed to challenge the government's evidence regarding the quantity of methamphetamine attributed to him, and failed to object to the career offender enhancement applied under the United States sentencing guidelines. Agent also contends that his appellate counsel failed to raise these issues on appeal. Upon review of the record, the court finds that Agent has failed to establish that his counsel's performance was deficient. The record demonstrates that Agent's trial counsel thoroughly cross-examined government witnesses, challenged the quantity of drugs attributed to Agent, and presented mitigating evidence at sentencing. Further, Agent's appellate counsel raised several issues on appeal, including the quantity of drugs and the application of the career offender enhancement. The Sixth Circuit rejected these claims, and Agent has not shown that his counsel's performance was unreasonable. Therefore, Agent's ineffective assistance of counsel claim is without merit. B. Career offender enhancement. Agent next challenges the application of the career offender enhancement to his sentence. Under the United States sentencing guidelines, a defendant is classified as a career offender if he has at least 2 prior felony convictions for either a crime of violence or a controlled substance offense. Agent argues that his prior felony conviction for drug trafficking should not have qualified as a predicate offense under the career offender guideline. However, the record reflects that Agent had not only 1 but 2 prior felony convictions that qualified as predicate offenses for the career offender enhancement. The first conviction was for drug trafficking, and the second was for armed robbery, a crime of violence. Both convictions meet the criteria for the career offender enhancement under USSG SS4 B1.1, and the enhancement was properly applied. Agent's challenge to the career offender enhancement is therefore denied. C. Firearms conviction. Agent also challenges his conviction under 18 U.S.C. SS 924 C for possessing a firearm in furtherance of a drug trafficking crime. Agent argues that the government failed to establish that he possessed a firearm during and in relation to the drug trafficking offense. He contends that the firearms found in his vehicle were not connected to any drug activity, and that the government's evidence was insufficient to support his conviction under SS 924 C. However, the testimony presented at trial contradicts Agent's assertions. Multiple witnesses, including law enforcement officers, testified that Agent and his co-defendants were heavily armed throughout their drug trafficking activities. Officers recovered firearms, ammunition, and other evidence commonly associated with drug trafficking from Agent's vehicle during his arrest. Additionally, witnesses testified that Agent brandished a firearm during the kidnapping of Ernest White. Given this evidence, the jury reasonably concluded that Agent possessed firearms in furtherance of his drug trafficking activities. Therefore, Agent's challenge to his SS 924 C. Conviction is without merit. D. Cumulative error. Finally, agent asserts that even if no single error warrants relief, the cumulative effect of the alleged errors deprived him of a fair trial. The cumulative error doctrine provides that a defendant may be entitled to relief if the combined effect of multiple errors rendered the trial fundamentally unfair, even if each error individually would not require reversal. In this case, however, agent has failed to demonstrate any errors in his trial or sentencing proceedings. As discussed above, the court has found no merit in agent's claims of ineffective assistance of counsel, career offender enhancement, or firearms conviction. Without any individual errors, there can be no cumulative error. Therefore, agent's cumulative error claim is denied. IV. Conclusion. For the reasons stated above, the court finds that agent is not entitled to relief under 28 U.S.C. SS 2255. The files and records in this case conclusively show that agent's claims lack merit, and no evidentiary hearing is necessary. Accordingly, agent's petition is denied, except with respect to his claim regarding the United States v. Combs issue, for which further briefing is necessary. Counsel will be appointed to represent agent for further proceedings on this limited issue. An appropriate order will enter. During McDavid and Howe's absence, petitioner and co-defendants Simpson and Bowers entered White's motel room. Upon entering, petitioner, dressed in black and wearing black gloves, struck White on the head with a walkie-talkie. Petitioner then showed a firearm and demanded $150 from White, which White owed for a drug-related debt involving methamphetamine. See Simpson, 116F. App X at 738. At trial, White explained the nature of the debt. R. 185. Trial TR. White at 228. 39. 59. Vance Bowers introduced White to petitioner, and for about 3 weeks, both White and Bowers worked for petitioner in his excavation business, which petitioner operated from his home. White mentioned that very little excavation work was actually done, and that many people who came to petitioner's business were not excavation customers. Petitioner owed White about $150 for 3 days of work. A few days before December 9, 2000, petitioner gave White a small amount of methamphetamine as payment for the work White had completed. Eyed Officer Melanie Church, a Kingsport police officer who interviewed White the morning after the incident, testified that White told her he had gone to petitioner on December 4, 2000, to get drugs for a friend, and that he owed petitioner $180. R. 184, Trial TR, Melanie Church at 54. When McDavid and Howe returned to the motel room and encountered petitioner, Bowers and Simpson, they initially thought they had entered the wrong room. Petitioner instructed them to stay and told Simpson to show a firearm he was carrying. Petitioner then placed a chair against the door to prevent anyone from leaving. Petitioner instructed McDavid, Howe, and White to hand over their cash, effectively robbing them. See Simpson, 116F. App X at 738. Not satisfied with the amount of cash collected, petitioner forced White to call his mother, Loretta Wuggeman, and ask her for $300. White's mother thought it was a joke until petitioner took the phone and firmly told her that it was not a joke, demanding the money. R. 184, Trial TR, and McDavid at 74 to 78, 87, 91 to 92. R. 185, Trial TR, White at 2 to 12, Howe at 71 to 74. R. 208, Trial TR, Loretta Wuggeman at 2 to 9. C. Simpson, 116F. AppyX at 73839. After the phone call, petitioner and co-defendants Simpson and Bowers forced the 3 victims out of the motel room and into a car to meet White's mother. Simpson followed in another vehicle and communicated with petitioner using 2-way radios. The victims were warned that if they made any attempt to escape, they would be harmed. They were also told that if White's mother didn't bring the money, they would be in serious danger. Ms. Wuggeman, White's mother, had already contacted the police and did not go to the meeting place. See Simpson, 116F. AppyX at 73839. When they couldn't locate Ms. Wuggeman, petitioner, Bowers, and Simpson, followed by Simpson, stopped at a coastal mart. Petitioner stepped out of the car, gave his weapon to Bowers, and told him to watch over the victims. Petitioner returned shortly afterward with some food and drinks. At petitioner's direction, White made another phone call to his mother, but she could not be reached. They left the Coastal Mart and drove back to the Westside Motel, where they saw several police cars in the parking lot. Petitioner grew increasingly angry, making threatening remarks to the victims as they drove towards Virginia. As they crossed the state line into Virginia, Bowers commented that they were now involved in a federal crime. See Simpson, 116F. App X at 739. The group stopped at a gas station in Virginia, and White unsuccessfully attempted to contact his mother again. Simpson parked behind Petitioner's vehicle and approached the group to talk with Petitioner. While Petitioner was outside of the car, Bowers remained inside, guarding the three victims. Howe testified that he didn't try to escape because Bowers was armed. R. 184, Trial T.R. McDavid at 79 to 80. R. 185, Trial T.R. White at 15 to 17, 47 to 48, 65. Howe at T.R. 75 to 79, 87 to 88, 95 to 96. C. Simpson, 116F. AppyX at 739. Petitioner then drove the group to a secluded area in Yuma, Virginia. Simpson parked behind Petitioner's vehicle, and the victims were forced out of the car. A weapon was pointed at McDavid's head, and he was ordered to follow instructions or he would be harmed. White and McDavid attempted to escape, and although White initially ran, both men were eventually captured. The victims managed to find help at a nearby house where a resident called the police. R. 184, Trial T.R. McDavid at 80 to 84. R. 185, Trial T.R. White at 12 to 22. 32, Howe at 71 to 87 to 88. C. Simpson, 116F. AppyX at 739. At trial, during McDavid's cross-examination, the defense suggested that McDavid had been enjoying a night out with friends and went willingly to Virginia, not as a victim of kidnapping, but to continue partying. McDavid rejected that version of events and explained, "Look here, brother, when you got a gun stuck to your head, you ain't doing much thinking about anything but your family and your life, whether you were going to live or you weren't going to live. I don't know if they thought this was a joke, but I didn't think it was a joke. But over $300, it ain't worth nobody losing their life." R. 184, Trial T.R. McDavid at 92 to 101. Defendants also argued that McDavid had stated in another context that he did not consider himself kidnapped. In response, McDavid testified, "Well, you got a gun pointed on you and you're made to get in the car, so what do you call it?" R. 184, Trial T.R. McDavid at 92 to 101. Harold Blanton of Scott County, Virginia, testified that White knocked on his door on December 9, 2000. When Blanton answered, White told him that he needed to use the phone because someone was after him. White made a call, and Blanton let White use the phone again after the initial call was not successful. R. 208, Trial T.R. Harold Blanton at 4 to 7. The police were eventually contacted, and officers took White and McDavid back to Kingsport, Tennessee. R. 184, Trial T.R. McDavid at 102 to 104. R. 185, Trial T.R. White at 55 to 60. At trial, evidence was presented that linked the events of the kidnapping to the broader methamphetamine distribution conspiracy. The testimony and evidence provided a clear picture of the involvement of all the individuals, including their roles in the drug business and the kidnapping scheme. The jury ultimately found the defendants guilty on several counts related to both drug distribution and violent crimes. The sentencing reflected the serious nature of the crimes committed, and the court concluded that the evidence supported the convictions. IV. Final trial testimony and sentencing. The final testimonies in the trial focused on the interconnected roles of petitioner, agent, and his co-defendants in the methamphetamine distribution network, along with their involvement in the kidnapping and violent incidents that followed. Law enforcement officers, forensic experts, and other witnesses provided further evidence that reinforced the prosecution's case. The government also introduced documents and phone records that confirmed communication between the defendants during the planning and execution of their criminal activities. Petitioner Jan did not testify in his defense. His attorneys attempted to discredit the government's witnesses and evidence but were ultimately unsuccessful in persuading the jury. The jury found Petitioner guilty on multiple counts, including charges related to drug trafficking, firearms offenses, and kidnapping. Sentencing phase. During the sentencing phase, the court considered Ajan's prior criminal history, including his prior felony drug conviction and a conviction for armed robbery. These prior convictions made Agin eligible for sentencing as a career offender under the United States sentencing guidelines, which significantly increased his potential sentence. Agin's defense argued for leniency, citing his personal circumstances and involvement in the drug trade as a lower-level participant. However, the court found that Agin's role in both the drug trafficking and the violent offenses was central and could not be minimized. Final sentence. On April 28, 2003, petitioner Agin was sentenced to 262 months of imprisonment on the drug and kidnapping offenses, followed by a consecutive mandatory 384-month sentence for the firearms convictions. The total sentence amounted to 646 months of imprisonment over 53 years. The sentencing judge noted the seriousness of the offenses and the need to impose a sentence that reflected the gravity of the harm caused to the victims. Agin's co-defendants, George Simpson and John Bowers, were similarly sentenced to lengthy terms of imprisonment for their roles in the conspiracy and related violent acts. The court's sentencing reflected the joint culpability of all three individuals in the broader criminal enterprise. Appeals and post-conviction motions. Following his sentencing, Agin filed multiple appeals and motions for post-conviction relief, including a direct appeal to the Sixth Circuit Court of Appeals. Agin's appeal raised several claims, including challenges to the sufficiency of the evidence, the application of the career offender enhancement, and the validity of his firearms conviction. The Sixth Circuit reviewed the trial record and upheld Agin's convictions and sentence in December 2004. Agin then petitioned the United States Supreme Court, but his petition for certiorari was denied. Agin also filed a motion under 28 U.S.C. SS 2255 to vacate, set aside, or correct his sentence, raising claims of ineffective assistance of counsel, improper application of sentencing enhancements, and other trial errors. As detailed earlier, the court denied most of Agin's claims but allowed further briefing on a specific issue related to United States v. Combs. However,
For those that came in late, I explained that I use an AI voice generator and that my daughter was in here yapping in my ear when I was doing this, and there were certain points that I got a little confused. So first of all, with AI voice generator, it doesn't always sound like the words it should. So that could just be a word. I don't know. I told you guys when I'm done covering this, I'm going to post the documents on I have a link to my Canva that you guys can get. I could share a link with you and you can read the documents. It doesn't give you access to my Canva or anything like that. But you'll be able to click the link and read all of the pages that I have up there. So if there's a word that's wrong, you'll be able to see it on the actual court documents tonight. Okay? All right.
However, the court ultimately denied Agin's request for an evidentiary hearing and reaffirmed the majority of the trial court's decisions. Conclusion. Petitioner Alan Mark Agin's involvement in a multi-state methamphetamine distribution conspiracy, combined with his participation in violent criminal acts, including kidnapping, resulted in significant legal.
I'm just saying, guys, this video is, this reading of this is 98 minutes long and 27 seconds. There's no way I was going to sit here that long and read this, so I had to cheat a little bit. I apologize. All right.
Consequences. His conviction and sentence were upheld through multiple appeals, and the courts consistently found that the evidence against Agin was overwhelming. Despite his post-conviction efforts to challenge the trial's outcome, the courts affirmed that his conviction and lengthy sentence were appropriate given the severity of the offenses. White and Howe managed to escape, and Howe told White that they needed to keep moving before anyone caught up with them. White wanted to use the phone, but they left the area. Blanton, the homeowner who helped them, went back inside and called the police. R. 207, trial TR, Harold Blanton, at 15 to 22. Philip Lane, from the Scott County, Virginia Sheriff's Department, responded to Blanton's call and arrived at Blanton's residence. Blanton pointed out 3 men near the road, and Lane drove up to meet the victims. The men explained that they had been kidnapped in Kingsport, Tennessee. Lane transported White, McDavid, and Howe back to Tennessee. R. 207, Trial TR, Philip Lane at 29 to 33. Kingsport Police Officer Melanie Church met Lane at the state line on December 9, 2000, and the victims were transferred into her custody. Officer Church testified that the victims told her they were taken to Virginia at gunpoint by petitioner Simpson and Bowers. They also mentioned that Simpson had used a 9mm firearm during the ordeal. During cross-examination, Church noted that the victims mentioned being robbed of $400. Additionally, White told her that he had obtained drugs for a friend on December 4, 2000, and had been fronted $180 worth of methamphetamine by petitioner. R. 184, Trial TR, Church at 44 to 47, 52 to 54. As part of the investigation, law enforcement obtained a warrant to search Simpson's residence on Ship Springs Road in Kingsport. Detective Frank Lipoma from the Sullivan County Sheriff's Department testified that officers found guns inside vehicles parked outside the house, as well as additional guns, 2-way radios, and a bulletproof vest inside the residence. R. 208, Trial TR, Frank Lipoma at 36 to 44. Testimony was also presented at trial concerning a recorded phone call made on December 7, 2002, by co-defendant Simpson while he was incarcerated. FBI agent Rainer Drolshagen testified about retrieving Simpson's call to White from the jail's computer system. Defendants objected to the admission of the tape, arguing that Drolshagen's testimony wasn't enough to establish a proper foundation. However, the court overruled the objection, and the tape was played for the jury. R. 208, Trial TR, Rainer Drolshagen at 54 to 65. In the recording, Simpson can be heard telling White to avoid being served with a trial subpoena and encouraging him to hide for about 10 days. Simpson suggested that if the victims didn't appear for trial, the kidnapping charge would be dropped. Before the trial, and in line with a ruling on the petitioner's motion, some statements by Simpson were redacted from the tape, such as those referring to Alan Ajon being the main one in references to drugs. R. 144, Magistrate's Pretrial Order. After Drolshagen's testimony, the United States rested its case. The defense presented only one witness, Officer Frank Light of the Sullivan County Sheriff's Department. Light's testimony addressed an earlier conversation between petitioner's ex-mother-in-law, Estelita Keller, and a juror, which had led to concerns about possible bias. As clarified in a court order from March 25, 2003, after investigating the matter, the court determined that the conversation was innocent, and the juror was not influenced. Light testified that he knew Keller, and that there was some type of dislike between petitioner and Keller. R. 208, Trial TR, Frank Light at 96 to 97. This testimony was introduced to explain the basis for any potential negative impression Keller may have created regarding petitioner. After Light's brief testimony, the defense rested, as did co-defendant Simpson. TR 97. So defendant Bowers presented testimony from an investigator with Federal Defender Services. The investigator stated that victim Curtis McDavid had said in an interview that he didn't feel that he, White, and Howe had been kidnapped. Charles Brown at 10001, David Quillen, from the Kingsport Police Department, testified that he had inspected the motel room where White was staying and found no evidence of a violent struggle. David Quillen at 11416. Finally, Bobby Perky testified that his conversations with White indicated that the situation wasn't as dangerous as it had seemed. Bobby Perky at 137. Standard of review. This court must vacate and set aside petitioner's sentence if it finds that the judgment was rendered without jurisdiction, or that the sentence imposed was not authorized by law or otherwise open to collateral attack, or that there has been such a denial or infringement of the constitutional rights of the prisoner as to render the judgment vulnerable to collateral attack. 28 U.S.C. SS 2255. Under Rule 4 of the governing rules, the court must initially consider whether the face of the motion itself, along with the exhibits and prior proceedings in the case, reveal that the movant is not entitled to relief. If it clearly appears that the movant is not entitled to relief, the court may summarily dismiss the S-2255 motion under Rule 4. When a defendant files a SS-2255 motion, he must set forth facts which entitle him.
Squall, this is what you wanted people to research. I asked you last week before I brought this out about an olive branch. I don't understand why you won't grab it. You started this. You do know I put my life in danger every time I show something from this. How can I not? This is what you asked people to research, right? I have to go back and listen to that. I didn't read the whole document, and I didn't expect Frank Light's name to just appear. Was it that he was snitching? Is that what they said? I'm a little blown away by that because I didn't expect that. I didn't read this. It's 4 pages long or something. 46 pages long. I think at the end I made a mistake. Kathy, Ziggy, Fred, Squall, Scott, Annie. The link's there.
To relief. Green v. Wingo 454 F.2D52 53 6th Sir. 1972 O'Malley v. United States 285 F.2D7 33 735 6th Sir. 1961 Allegations of fact that merely have some probability of verity are not enough to warrant a hearing. O'Malley 285 F.2D at 735. A motion that only makes conclusory statements without specific and credible factual support will not be enough to justify a hearing. Petitioner's claims for relief under SS 2255 include arguments regarding ineffective assistance of counsel, improper application of sentencing enhancements, and errors during trial. Each of these claims will be analyzed in accordance with the applicable legal standards for relief under S 2255, as well as the relevant facts from the case's record. General conclusions of law without substantiating allegations with facts are without legal merit. Loom v. Underwood 262 F.2D 866 867 6th Sir. 1959 United States v. Johnson 940 F. Sup. 167 171 W.D. 10 1996. To warrant relief under 28 U.S.C. SSS 2255, because of constitutional error, the error must be of constitutional magnitude, which had a substantial and injurious effect or influence on the proceedings. Brecht v. Abrahamson, 507 U.S. 619, 637, 1993, citation omitted, Clemens v. Soders, 34 F.3D 352, 354, 6th Sir. 1994. See also United States v. Kappas 29 F.3D 1187, 1193, 7th Sir. 1994. If the sentencing court lacked jurisdiction, the conviction is void and must be set aside. Williams v. United States, 582 F.2d 1039, 1041, 6th Sir. 1978, cert. Denied, 439 U.S. 988, 1978. To warrant relief for a non-constitutional error, the petitioner must show a fundamental defect in the proceeding that resulted in a complete miscarriage of justice or an egregious error inconsistent with the rudimentary demands of fair procedure. Reed v. Farley, 512 U.S. 339, 354, 1994. Grant v. United States, 72 F.3d 503, 506, 6th Sir. 1996, cert. Denied, 517 U.S. 1200, 1996. In order to obtain collateral relief under SS 2255, a petitioner must clear a significantly higher hurdle than would exist on direct appeal. Sixth Amendment and ineffective assistance of counsel. The Sixth Amendment provides, in pertinent part, that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. U.S. Const. Amend. VI. A defendant has the right not only to counsel but to the reasonably effective assistance of counsel. Strickland v. Washington, 466 U.S. 668, 687, 1984. In Strickland, the Supreme Court set forth a two-pronged test for evaluating claims of ineffective assistance of counsel. First prong, deficiency of performance. First, the defendant must show that counsel's performance was deficient. This requires showing that counsel made errors so serious that they were not functioning as the counsel guaranteed by the Sixth Amendment. The defendant must demonstrate that the deficient performance prejudiced the defense. This requires showing that counsel's errors were so serious that they deprived the defendant of a fair trial, a trial whose result is reliable. Unless a defendant makes both showings, it cannot be said that the conviction resulted from a breakdown in the adversary process that renders the result unreliable. Strickland, 466 U.S. at 687. As with any other claim under SS 2255, the burden of proving ineffective assistance of counsel is on the petitioner. Virgin Islands v. Nicholas, 759 F.2d 1073, 1081, 3d Sir. 1985. In considering the first prong of the test set forth in
I have been live an hour. We are about 40 minutes in. Like I said, this is 98 minutes and 27 seconds. I think I'm going to go to about 45 minutes and then cut this and come back tomorrow afternoon because I want to get to my husband wants to react to the Wade Wilson stuff, and I want to listen to a few more minutes of Prayer Garden from last night. Or if you guys don't want to do that, because I think, no, is Andrew around? He was going to come back later. I only want to go over the Prayer Garden if Andrew's around. Andrew, are you watching? I don't think that he is. So I'm not going to go over the Prayer Garden stuff. Do you guys want to continue this, or I guess we'll continue it? Because I really do want to go over the Prayer Garden stuff with Andrew. There's a partner about the bikers. There's also some other stuff that I think may connect to this and other things that I spoke about in my live earlier that I want to start addressing a little bit of, and that's definitely what Squall wanted us to look at. However, with the names, the connections, the court hearings, the this, the that, this guy involved with the Jason Arnold case, and this with the Simpson, and somebody related to Kathy Gordon, 100%. I asked Kathy, Ziggy, and Fred to grab a link to tell us what they know about this. Because now that tells me that Kathy and Fred knew each other. That's why Kathy was comfortable taking a stranger into her home to stay there. The question is, how does Ziggy play into that? These are things I've been trying to show for a long time. Some of them. This one is kind of new to me, a few months. I covered it once before. It was the day or around the time that I showed you, because maybe that's why I started looking it up. But I had showed you that Fred, Kathy, and somebody else in Kathy's car, I believe to be her son, stopped. I forget the name of the road. What's the name of the road? Mountain Drive or something? Up by Laurel Run. They stopped and somebody had gotten out of the car. Because of this opens up a couple theories. I have two. Allison stated, and this is what I showed in my first live from earlier. Allison had made a statement that Summer, I need to light this fucking joint. I just waste them. Summer loved to go to the Laurel Run. I think it's family, Lorianne. Fred's definitely related to Simpsons. You got to remember his sister spoke a little bit about this in my chats. That's why I'm saying go back and look if you can find them. Just go back maybe a month or two. Just look for ones about Fred. I thought it was her grandson, and I don't know who it was, Cotton Candy. You couldn't see them. I asked Fred to grab a link and answer, and he came in my chat, and he said that he would. And then he never came back to my chat again. Ziggy took a small break. And then she came back trying to sell things, and now she's cooking. She has made statements like, I don't understand why I can't answer other creators. It is my opinion that this is what she's referring to. Yes, there is another Frank Light that is a cop running bear. It's my opinion they're related. I don't know that for sure. He's retired. He's an older guy. But I did question Jody about him. I can't remember if it was live on panel or in a video call. It's something that wasn't recorded. But Jody rolled her eyes at me when I said, well, they can't be. Are they related? Like, that wouldn't be Frank is Grady's son. And Jody kind of rolled her eyes at me and said, well, and then just continued and wouldn't answer me. So, Frank Light, he's a cop named Frank Light, but it's not the same Frank Light as the Frank Light we've all come to know. But the Frank Light we all come to know, his father is Grady Light, not Frank Light. And this guy, maybe an uncle, a cousin, I don't know. And I'm not digging into these people. That's what I had said earlier today for those that weren't in my live. This is dangerous territory, guys, and it's going to get even more dangerous, okay? So I need to be careful how I do this. I kind of want to try to redact names and things like that. I value my life. But what I want to do is show you the different states and different parts of Tennessee. And it actually makes me curious as to why Benny calls Jody's daughter Chattanooga. But we'll get there. In that bust with James Light, there were judges involved. There were cops involved. There were doctors involved. It involved different states. The same I just covered. Something in Louisville, right? Not too long ago, because there was a missing baby, and it turned out that the baby died of drug overdose. And then there's this big bust, right? The same organization that made that bust made the James Light bust, that OCDTF. So that's another good refresher if you want to go back and watch my coverage on that. Guys, when I research, but we got to be careful. I was bullied here, like, put out what you know, put out what you know. This is dangerous for me to do. Do you understand that? I really want to try to keep people's names out of it because I don't want to die. I don't mind covering this right here because this is Ajon. Dawn worked with them. That's this. These are all names. And Fred's alive and out there. Kathy's alive and out there. So I want to take my time with the bus stuff. You guys are welcome to look it up. It's all public information. But I ain't going to be out here snitching on people. People can fucking figure that shit out for themselves. If you understand what I'm saying. I'm sure the police are well aware of it since Squall has been screaming since the beginning. This route that nobody was ever willing to take. I am, however, I want to do it responsibly. I just want to share public stuff. I don't want to search their Facebooks. I don't want to go to Ben Verified. I just want to show you what's public. And I advise that you guys do the same. And I'm going to tell you that this is why I believe whatever happened to Summer is far bigger than we could even imagine or even try to even take on ourselves. However, I think the misinformation needs to be untangled. I explained that in my live earlier today. You got to watch it. I hope you guys will listen. Take the advice. Be responsible. Just listen to what's put out. Don't follow up on it. This is it. It's time we just start keeping Summer's name out there, untangling the mess, showing how dangerous this could actually fucking get, right? And then let Dawn Candace, the locals, handle it themselves. Here's something I'm going to say. That bust, oh my God. The amount of drugs, the type of drugs, the states, that was probably the biggest bust in America. Okay? There are people that were indicted, but not indicted. There are aspects of people that moved marijuana from Tennessee up to New York. Andy admitted to trafficking marijuana to Washington, D.C. the last time he was on my panel. There's rumors that Andy and Jody Sue snitched. They were arrested at the same time as these people. This was a few years long investigation. This was a huge investigation. And we can cover the public aspect of it, the court records. However, I think it's time to stop digging so personally into Summer's case. And this is why. Oh my God, you sounded like Bailey coming in. You going somewhere?
I'm gonna have to.
Okay, well, you got to react to Wade when you come back.
Yeah.
I'll let them listen to this until you get back. My husband got to go to the store and get dinner. We were supposed to have shepherd's pie tonight, but my daughter decided, and I'm not even supposed to eat this shit. I did it for her, and my daughter decided they're going to go out to eat. So we've decided at 7 o'clock what we're going to have for dinner, which is, I still didn't decide. What are we having?
We don't, I guess pizza. I'll tell you what happened. I was trying to order it, but that wasn't no good.
Why? I don't know. He couldn't order a pizza. He took money out of the bank and didn't leave enough on the card.
No,
All right, let's go. Let me put this on for you and see what the fuck's going on with my husband. He's whispering. I don't want it to sound secretive. It's just trying to order pizza, dude. They'll turn it around into a drug dealer from the pizza man. Okay.
Strickland. The appropriate measure of attorney performance is reasonableness under prevailing professional norms. Strickland, 466 U.S. at 688. A defendant asserting a claim of ineffective assistance of counsel must identify the acts or omissions of counsel that are alleged not to have been the result of
He's such a dork. You guys know I don't use my phone all that much, right? He uses his only at work, mainly on Wi-Fi, because we video message each other. My daughter mainly uses Wi-Fi. He's whispering to me, I couldn't order because our phones are off. He forgot to pay the fucking bill. Now we can't pay it till Thursday. So that was the problem. We're not drug dealers. He didn't have to make that secretive. I apologize. That was ridiculous. Husbands. And I'm an open book. Love you guys. Let's listen.
reasonable professional judgment. Id. At 690. The evaluation of the objective reasonableness of counsel's performance must be made from counsel's perspective at the time of the alleged error, and in light of all the circumstances, and the standard of review is highly deferential. Kimmelman v. Morrison, 477 U.S. 365, 381, 1986. Second prong, prejudice to the defense. The second prong of the Strickland test requires the petitioner to show that counsel's deficient performance prejudiced the defense. Thus, an error by counsel, even if professionally unreasonable, does not warrant setting aside the judgment of a criminal proceeding if the error had no effect on the judgment. Strickland, 466 U.S. at 691. The petitioner must show there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Id. At 694. The Strickland court emphasized that both prongs must be established in order to meet the claimant's burden, and if either prong is not satisfied, the claim must be rejected. The court noted.
Earl, did you know you can order pizza online? Well, yeah. Duh. I love that man. He's gonna order pizza. We're gonna eat tonight and he doesn't have to leave the house. Jesus Lord. He probably thought I was gonna be mad about the phone. I'm not. I don't even use it. Okay.
Although we have discussed the performance component of an ineffectiveness claim prior to the prejudice component, there is no reason for a court deciding an ineffective assistance claim to approach the inquiry in the same order or even to address both components of the inquiry if the defendant makes an insufficient showing on one. If it is easier to dispose of an ineffectiveness claim on the ground of lack of sufficient prejudice, which we expect will often be so, that course should be followed. Courts should strive to ensure that ineffectiveness claims do not become so burdensome to defense counsel that the entire criminal justice system suffers as a result. I'd at 697. IV. Analysis and discussion. A. Issue I. Ineffective assistance of counsel. EAC search of defendant's car. Agent was stopped by Kingsport Police Officer Eric Alford on November 26, 2000 for suspected drunk driving and was subsequently arrested. A search of his vehicle.
I can't remember. I'm going to have to look again. Maybe in some of my recent Ernie Shell information. Alford's from the Hay House, I believe.
Incident to arrest resulted in the seizure of a quantity of white powder in a cigarette pack, digital scales, and a box of baggies. The white powder was determined by the Tennessee Bureau of Investigation Crime Laboratory to be 22.2 grams of methamphetamine. Alford also found a cell phone in the vehicle. Alford dialed the last number called on the cell phone, reaching co-defendant George Simpson. Without identifying himself, Alford told Simpson that Agent had passed out and needed help. Simpson told Alford that Agent was his boss and asked him to bring Agent to the Coastal Mart on Bloomingdale, where they would meet. Agent claims that his attorney failed to properly present Fourth Amendment claims. Doc. 277 at 5. Characterizing the search of his car as an inventory search. Agent claims that his attorney failed to challenge the search as being in violation of interdepartmental policy and was simply a pretext for gathering evidence. Id. at 5 to 6. He also claims that Alford's seizure and use of the cell phone was illegal. B. Court's evaluation of the search and counsel's actions. Petitioner's claim lacks merit. His trial counsel filed a motion to suppress the evidence. The magistrate judge held an evidentiary hearing, and a report and recommendation, RR, was filed, finding no Fourth Amendment violation. Petitioner's attorney timely objected to the RR, but the district judge overruled the objection and held that there was no Fourth Amendment violation. Agent did not raise this issue on direct appeal. Petitioner cannot show deficient performance by his counsel regarding this issue. Agent's argument that the November 26th search was an inventory search, not conducted according to established police procedures, is irrelevant. Alford testified that he did an inventory of that vehicle, and the record shows that Agent was properly arrested for drunk driving. A subsequent search of his person revealed 2 or 3 bags of pills. When a person is lawfully arrested, as Ajan was, the passenger compartment of the vehicle and any containers therein may be searched without a warrant or further cause. New York v. Belton, 453 U.S. 454, 1981, United States v. Riascos Suarez, 73 F.3D 616, 625, 6th Sir. 1996, cert. Denied 519 U.S. 848, 1996. Even if the vehicle search had not been permitted, the discovery of pills on Agent's person would have provided probable cause to search the car for contraband. See Arizona v. Gant and its impact. The Supreme Court's recent decision in Arizona v. Gant, 556 U.S. __ 129 S. Seat 1710, 2009, calls into question the continued viability of New York v. Belton. However, Officer Alford had probable cause to search the vehicle for contraband, making the search valid under the circumstances. Ojan's attorney raised all appropriate Fourth Amendment issues at trial and on appeal, and the district judge found no Fourth Amendment violation. Ojan's claim that his attorney failed to properly present these issues is therefore without merit. D. Conclusion of Fourth Amendment claims. In conclusion, Agent has failed to demonstrate that his counsel's performance regarding the Fourth Amendment issues was deficient. Furthermore, even if counsel had been deficient, Ojan has not demonstrated how the alleged errors prejudiced his case. The evidence against Ajahn, including the methamphetamine and the phone call linking him to Simpson, was overwhelming. There is no reasonable probability that the outcome of the case would have been different had the Fourth Amendment claims been presented differently. V. Conclusion. For the reasons stated above, the court finds that Ajahn has not established that he is entitled to relief under 28 U.S.C. SS 2255. Petitioner has failed to demonstrate ineffective assistance of counsel, and his claims regarding the Fourth Amendment violations have no merit. The evidence presented at trial was sufficient to support the jury's findings of guilt, and petitioner has not shown that his conviction or sentence should be vacated or set aside. Accordingly, the petition for relief under SS 2255 is denied. An appropriate order will enter.
And this statement may get me killed, but Jody Sue, remember when you called me lazy and I didn't do research? Kiss my ass, toxic. Quit talking shit on people. You're the reason we're here. With your fucking setting me up for lawsuit bullshit, right? Go hard or go home. By the way, this is a conversation channel. Everything here is speculation based on public information. All right. Oh, and my opinions do not reflect the opinions of others. They are my opinions. I am solely here to give you my opinion and show you things that I have found online publicly. No really need for copyright on this one. It's my research. But I'm lazy, Jody.
Whether or not the occupant of a vehicle is arrested, warrantless searches of vehicles are permitted if there is probable cause to believe the vehicle contains evidence of a crime and exigent circumstances exist. Chambers v. Maroney, 399 U.S. 42, 52, 1970, Carroll v. United States, 267 U.S. 132, 1925. The vehicle exception is applicable even in non-exigent circumstances as long as the vehicle is mobile and law enforcement officers have probable cause to believe it contains incriminating evidence. Maryland v. Dyson, 527 U.S. 465, 466, 67, 1999, United States v. Cope, 312 F.3D7, 576/2002. Where police have probable cause to believe that a vehicle contains contraband, they may search the entire vehicle and any contents located within it. United States v. Mans, 999 F.2D 966, 968, 6th Sir, Cert. Denied, 510 U.S. 999, 1993. It is clear that Officer Alford's post-arrest seizure of Ajahn's cell phone from his vehicle was lawful, as the seizure resulted from a valid search. Ajahn, however, argues that Alford's use of the cell phone was illegal. The Fifth Circuit considered that very question and rejected Ajahn in United States v. Finley, 477 F.3D 250, 5th Sir, Cert. Denied, 127 S. See 2065-2007. In Finley, the court held that, since the cell phone was properly seized, the police were permitted to search the cell phone pursuant to the arrest, 477 F.3D at 260. See also United States v. Ordis 84 F.3D 977, 984 7th Sir. 1996. Upholding retrieval of information from a pager as a search incident to arrest. Failure to object to recorded detention center telephone call. Petitioner next asserts that his trial counsel was ineffective for not objecting to the introduction of a recording of a telephone call placed on December 7, 2002, by co-defendant Simpson to Ernest Lynn White, the victim of the kidnapping, while Simpson was incarcerated at the Washington County Detention Center, WAC. All inmate calls from the WAC are monitored and recorded by the jail computer system. Inmates are advised prior to each call that the call will be recorded. Petitioner's counsel filed a motion in limine regarding the recording pursuant to Bruton v. United States 391, U.S. 123, 1968. On the recording, Simpson encouraged White to avoid a government trial subpoena and told him the kidnapping charge would be dismissed if the victims did not appear for trial. As a result of petitioner's in limine motion, portions of the recording that referred to Agin were redacted and were not heard by the jury. Ogin now asserts that the recording of inmate telephone calls at the WACT violated the Electronic Communications Privacy Act, ECPA, and that his attorney's failure to object to its introduction on this ground constituted ineffective assistance of counsel. Court's analysis of the ECPA claim. Agin's position lacks merit for several reasons. First, the ECPA is expressly limited to electronic communications for which a person has an expectation of privacy. See ACLU v. NSA 493F.3D 644, 6th Sir. 2007. It cannot reasonably be argued that an inmate has any expectation of privacy in a jailhouse phone call, where the inmate is expressly warned that the call is subject to monitoring and recording. Second, there is no exclusionary rule generally applicable to statutory violations. United States v. Abdi 463 F.3D 547, 556, 6th Sir. 2006. The Sixth Circuit has specifically held that a violation of the ECPA does not warrant suppression of evidence. See United States v. Meriwether 917 F.2D 955, 960, 6th Sir. 1990, holding that the Act does not provide an independent statutory remedy of suppression for interception of electronic communications. Therefore, it was not deficient performance for Agin's trial counsel not to object to the introduction of the recording at the WACT on the basis of the ECPA. Prejudice claim regarding the recorded call. Further, even if petitioner could meet the first prong of the Strickland test and establish deficient performance by his counsel, he cannot establish any prejudice from the introduction of the recording. The trial court granted Agin's motion in limine, and all references to Agin were deleted from the recording and were not heard by the jury. Issue II, IAC, fabricated facts evidence. Petitioner argues that counsel was ineffective in failing to argue that a Franks hearing was required because of what he refers to as fabricated facts evidence and contradictions in the testimony of several officers who testified. Petitioner somewhat retreats from his initial position in his reply to the government's response to his petition. Ogin acknowledges that the initial claim was drafted by another inmate and expresses uncertainty about whether a Franks hearing was the best course of action his trial counsel should have taken. Doc. 15 at 2-3. The rambling nature of petitioner's pleadings makes it difficult to ascertain the precise issue being raised, but it is clear that petitioner accuses the law enforcement officers involved of making false statements in their affidavits in support of search warrants and providing perjured testimony at trial. Standard for a Franks hearing. In order to be entitled to a hearing pursuant to Franks v. Delaware 438 U.S. 154, 1978, commonly referred to as a Franks hearing, a defendant must make a dual showing, which incorporates both a subjective and an objective threshold component. Aid at 15556. First, the defendant must make a substantial preliminary showing that a false statement knowingly and intentionally, or with reckless disregard for the truth, was included by the affiant in the warrant affidavit. Second, the allegedly false statement must be necessary to the finding of probable cause. I'd at 15556. A Franks hearing is warranted only if the defendant makes a substantial showing of both prongs of this test. General or conclusory allegations of perjury or false testimony are insufficient to justify a hearing. Instead, the defendant must provide an offer of proof, accompanied by a detailed statement of supporting reasons. I'd at 171. Application of the Franks standard to Agin's case. Petitioner has failed to make the required substantial showing necessary to warrant a Franks hearing. His assertions that law enforcement officers made false statements in their affidavits are vague and unsupported by any specific evidence. Petitioner provides no detailed offer of proof or supporting reasons that would demonstrate that the officers knowingly or recklessly made false statements. As such, petitioner's claim regarding fabricated evidence and the need for a Franks hearing is without merit. Additionally, even if petitioner had made the necessary showing, there is no evidence that the alleged false statements were material to the finding of probable cause. The evidence against petitioner, including the methamphetamine found in his vehicle and the phone call linking him to co-defendant Simpson, provided ample probable cause for the issuance of the search warrant and the subsequent search of petitioner's vehicle. Issue IAC failure to investigate witnesses. Petitioner next claims that his trial counsel was ineffective for failing to investigate certain witnesses who allegedly would have provided exculpatory testimony. Specifically, petitioner claims that counsel should have interviewed additional witnesses who could have contradicted the testimony of the government's witnesses. In order to prevail on an ineffective assistance of counsel claim based on a failure to investigate, a defendant must show that counsel's performance was deficient and that the deficient performance prejudiced the defense. Strickland, 466 U.S. at 687. A claim based on a failure to investigate requires a showing of what evidence would have been discovered and how it would have affected the outcome of the trial. United States v. Kaufman, 109F.3D 186, 191, 3D Sir. 1997. Failure to investigate. Agent's specific claims. Petitioner fails to identify the specific witnesses who should have been interviewed and what exculpatory information they would have provided. Petitioner offers only vague and conclusory statements that additional witnesses could have contradicted the government's case. Such generalized assertions are insufficient to meet the burden of proof required under Strickland. Without specific evidence of what these witnesses would have said and how it would have affected the outcome of the trial, petitioner's claim of ineffective assistance of counsel based on a failure to investigate cannot succeed. Prejudice standard not met. Even if petitioner could show that counsel's performance was deficient in failing to investigate these witnesses, he has not shown that the outcome of the trial would have been different had these witnesses been called to testify. The evidence against petitioner, including the physical evidence found in his vehicle and the testimony of multiple witnesses linking him to the drug distribution conspiracy, was overwhelming. Petitioner has not demonstrated that the alleged failure to investigate witnesses prejudiced his defense in any way. Failure to object to the prosecutor's remarks. Petitioner also claims that his trial counsel was ineffective for failing to object to certain remarks made by the prosecutor during closing arguments. Petitioner argues that these remarks were improper and prejudiced the jury against him. In order to succeed on an ineffective assistance of counsel claim based on a failure to object to prosecutorial misconduct, the petitioner must show that the prosecutor's remarks were improper and that there is a reasonable probability that, but for counsel's failure to object, the outcome of the trial would have been different. United States v. Frady, 456 U.S. 152, 164, 1982. Prosecutor's remarks analyzed. The petitioner has not identified the specific remarks made by the prosecutor that he claims were improper. A review of the trial transcript reveals no comments by the prosecutor during closing arguments that could be considered improper or prejudicial. The prosecutor's comments were focused on the evidence presented at trial and were within the bounds of permissible advocacy. Even if the prosecutor's remarks were improper, the petitioner has not demonstrated that there is a reasonable probability that the outcome of the trial would have been different had counsel objected. The evidence against the petitioner was overwhelming, and the prosecutor's remarks were not so prejudicial as to affect the jury's verdict. Issue v. IAC cumulative error. Finally, the petitioner argues that the cumulative effect of trial counsel's errors deprived him of a fair trial. Under the doctrine of cumulative error, a defendant may be entitled to relief if the cumulative effect of multiple errors rendered the trial fundamentally unfair, even if each individual error would not warrant relief on its own. In this case, however, petitioner has not demonstrated any errors by trial counsel. As discussed above, each of petitioner's claims of ineffective assistance of counsel lacks merit. Without any individual errors, there can be no cumulative error. Therefore, petitioner's cumulative error claim is without merit. VI. Conclusion. For the reasons stated above, the court finds that petitioner has not demonstrated that his trial counsel's performance was deficient, nor has he shown that he was prejudiced by any of counsel's alleged errors. Petitioner has failed to meet the burden required to succeed on his ineffective assistance of counsel offense. Accordingly, petitioner's motion under 28 U.S.C. SSS 2255 to vacate, set aside, or correct his sentence is denied. An appropriate order will enter. Standing to challenge the search of Simpson's residence. Agent specifically points to the affidavit of Officer Glenn Craddock, which was submitted on December 9, 2000, in support of a search warrant for the residence of co-defendant Simpson. Agent spends many pages of his memorandum discussing perceived false statements by Officer Craddock in the affidavit. Agent further complains that Craddock's affidavit contains facts provided by third parties in violation of Crawford v. Washington 124S.CT 1354, 2004. Petitioner's arguments about alleged falsehoods in the Craddock affidavit are completely immaterial. The Craddock affidavit was offered in support of a request for a search warrant to search the residence of co-defendant Simpson. Petitioner Agent has absolutely no standing to contest the legality of the search of Simpson's residence. To have standing to challenge the legality of a search under the Fourth Amendment, a defendant must have a reasonable expectation of privacy in the place to be searched. Rokas v. Illinois 439 U.S. 128, 143, 1978. Ajan had no reasonable expectation of privacy in Simpson's residence and thus lacks any standing to challenge the legality of the search. As a result, Agent would not have been entitled to a Franks hearing even if he could have shown false statements in the Craddock affidavit. Counsel was not deficient in failing to seek such a hearing. Other search-related issues. Another issue needs to be briefly addressed. Agent argues in his reply brief that the affidavit of Craddock was incorporated, in Depew's search warrant for Agent's home, giving him the standing required to contest the legality of the search. A review of Officer Depew's affidavit in support of the search warrant for Agent's residence at 1747 Valley Road, Churchill, Tennessee, shows that the affidavit makes no reference to the Craddock affidavit. Petitioner's argument is wholly without merit. Fabricated facts allegation. Petitioner further argues that the affidavit of complaint filed by Officer Hickman upon Ajan's arrest for DUI contained numerous misrepresentations, and that Officer Alford's affidavit of complaint filed in connection with the arrest of George Simpson on November 27, 2000, also contained misrepresentations. Additionally, Agent claims that Officer Hickman and Officer Melanie Church committed perjury at trial. He argues that these alleged fabricated facts evidence became an integral part of the federal prosecution. Agent points to pretrial motions filed by defense counsel, the government's responses, and court rulings as evidence of this. Petitioner's arguments lack specificity. Other than making conclusory statements about counsel's failure to contest these alleged fabricated facts, petitioner makes no effort to explain what exactly counsel could or should have done differently or how he was prejudiced by counsel's alleged failures. Such conclusory allegations are insufficient in a SS 2255 proceeding. Furthermore, to the extent petitioner is arguing that the evidence against him at trial was insufficient to sustain a conviction, that argument may not be raised in a SS 2255 proceeding. See Scott v. Morrison 58F, Appx 602 6th Sir, 2002. As the government correctly points out in its response, petitioner was convicted by a jury after full consideration of the trial evidence, and he confronted all witnesses against him. Chain of custody argument. Petitioner argues that his trial counsel was ineffective for failing to object to the chain of custody related to the methamphetamine found in Ajan's possession. Ajan points to the testimony of forensic scientist Jacob White and the forensic chemistry reports that were introduced at trial. However, petitioner does not claim that the officers tampered with or altered the evidence. Chain of custody and authentication. Federal Rule of Evidence 901 provides that authentication or identification as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. Fed. R. Evid. 901. Physical evidence is admissible when the possibilities of alteration or misidentification are eliminated, not absolutely but as a reasonable probability. United States v. McFadden, 458 F.2d 440, 441, 6th Sir. 1972. Where no evidence exists to indicate that tampering with an exhibit occurred, the court presumes that public officers have properly discharged their duties. United States v. Allen, 106 F.3d 695, 700, 6th Sir, Cert. Denied, 520 U.S. 1281, 1997, merely raising the possibility that someone tampered with evidence is insufficient to render evidence inadmissible. Challenges to the chain of custody go to the weight of the evidence, not its admissibility. United States v. Levy 904 F.2d 1026, 1030, 6th Sir. 1990. Petitioner's claim lacks merit. This claim also lacks merit. The record establishes and petitioner acknowledges that his counsel cross-examined the government's witnesses on the issue, and he makes no claim that the evidence was tampered with, raising at most a claim of the mere possibility of tampering. Counsel's performance was in no way deficient, and absent evidence of tampering, no basis existed for counsel to object to the admissibility of the methamphetamine, even were it shown that counsel should have raised additional objections to the chain of custody. Petitioner has not demonstrated that he was prejudiced by counsel's actions. Issue V, Yak Cumulative Error Doctrine. Lastly, petitioner raises the argument of cumulative error. Under this doctrine, a court may find that while no single error requires reversal, the cumulative effect of multiple errors may result in an unfair trial and require relief. United States v. Parker, 997 F.2 219, 221, 6th Sir. 1993. To prevail under a cumulative error theory, a petitioner must show that the cumulative effect of the alleged errors deprived him of a fair trial. Cumulative error analysis in Ajan's case. Petitioner has not demonstrated any errors by trial counsel, let alone multiple errors. As discussed previously, each of petitioner's claims of ineffective assistance of counsel lacks merit. Without individual errors, there can be no cumulative error. Petitioner has failed to show that his trial counsel's performance, either individually or cumulatively, resulted in an unfair trial. Conclusion on cumulative error. For these reasons, petitioner's claim of cumulative error fails. The performance of trial counsel, viewed both individually and cumulatively, was not deficient, and petitioner has not demonstrated any prejudice resulting from counsel's conduct. Accordingly, petitioner's cumulative error argument is without merit. VII. Conclusion of all claims. After thoroughly reviewing petitioner's claims, the court finds that none of the arguments raised in his S-2255 motion have merit. Petitioner has failed to demonstrate that his trial counsel's performance was deficient in any respect. Additionally, even assuming arguendo that counsel's performance was deficient in some way, petitioner has not shown that any alleged deficiency prejudiced his defense or affected the outcome of the trial. Petitioner's claims regarding the Fourth Amendment, the chain of custody, alleged fabricated evidence, and cumulative error have all been thoroughly addressed and found to be without merit. Petitioner was convicted by a jury based on overwhelming evidence of his guilt, and nothing in the record suggests that he was deprived of a fair trial. Order denying relief. As a result, petitioner's motion to vacate, set aside, or correct his sentence under 28 U.S.C. SS-2255 is denied. Petitioner has not demonstrated that he is entitled to any relief, and the court concludes that no evidentiary hearing is required. The clerk of court is directed to close this case. E. Issue IV, IAC multiplicious counts. Petitioner next alleges that trial counsel was ineffective for failing to raise the multiplicity, sic, of counts 1, 2, 3, and 4 of the indictment in the case. Counts 1 and 2 of the indictment charge Ajan and others with conspiracy to distribute and to possess with the intent to distribute 5 grams or more of methamphetamine, count 1, and conspiracy to distribute and to possess with the intent to distribute a quantity of less than 5 grams of methamphetamine, count 2. Counts 3 and 4 each charge possession with intent to distribute methamphetamine, 5 grams or more for count 3, and a quantity less than 5 grams for count 4. The jury was instructed by the court to consider counts 2 and 4 only if they found the defendant not guilty of the charges in counts 1 and 3. The jury convicted Ajan on counts 1 and 3. An indictment is multiplicious if it charges a single offense in more than one count. United States v. Stevens, 118 F.3d 479, 6th Sir. 1997. However, a multiple count indictment, based on the same underlying conduct, is not multiplicious as long as each count requires proof of an element not required by the other. United States v. Kelly, 204 F.3d 652, 656, 6th Sir, cert. Denied, 530 U.S. 1268, 2000? Alternatives to counts 1 and 3. These counts were not multiplicious. Furthermore, even if counts 2 and 4 had not been set out as separate counts in the indictment, a lesser included offense instruction would have been given to the jury. Agin suffered absolutely no prejudice since he was convicted only of counts 1 and 3. Not only that, even if the jury had returned verdicts of guilty on all 4 counts, an option they were not given, the remedy would have been to merge the convictions for sentencing purposes. See United States v. Thronberg, 921 F.2d 654, 657, 6th Sir. 1990. This issue lacks merit. F. Issue v. Yak petitioner's failure to testify. Petitioner alleges that he received constitutionally deficient counsel when counsel failed to allow petitioner to testify on his behalf. Doc. 2 at 23. The defendant correctly argues that the decision by a defendant to testify or not is personal, and the right to testify cannot be waived by the defendant's counsel on his behalf. C. Jones v. Barna, 463 U.S. 745, 751, 1983. In support of his claim, petitioner has submitted affidavits from his parents as well as his own affidavit. Petitioner's affidavits regarding testimony. Ajayan's mother states that during the lunch break on either the first or second day of the trial, she was told by her son's trial counsel, "Alan wants to testify, but I will not put him on the stand because it would not do him a bit of good and may hurt him." Ajayan's father states that during the lunch break in the hallway, he was told by his son's attorney, "Alan wants to testify, but I do not want to let him do that for himself. He would only hurt himself." Ajayan's own affidavit states that he was barred from testifying by his attorney, and if allowed to do so, would have testified truthfully that he was being railroaded. Both of Ajayan's parents saw Ajayan and trial counsel in a heated discussion after the government's last witness testified. However, the defendant's attorney rested the case without calling the defendant to the witness stand. Sixth Circuit ruling on testimony. The defendant's argument has been foreclosed by a recent decision of the Sixth Circuit. In United States v. Stover, 474 F.3d 904, 6th Sir. 2007, the Sixth Circuit, quoting United States v. Weber, 200 F.3d 545, 6th Sir. 2000, stated, although the ultimate decision whether to testify rests with the defendant, when a tactical decision is made. Sixth Circuit ruling on testimony continued. Although the ultimate decision whether to testify rests with the defendant, when a tactical decision is made not to have the defendant testify, the defendant's assent is presumed. United States v. Jolson, 7F.3d 174, 177, 9th Sir. 1993. Bearing any statements or actions from the defendant indicating disagreement with counsel or the desire to testify, the trial court is neither required to sua sponte address a silent defendant nor to inquire whether the defendant knowingly and intentionally waived the right to testify. In this case, there is no indication that Ajayan alerted the trial court of any desire to testify or disagreement with his counsel's decision. As such, this issue lacks merit. G. Issue VI. Yak Blakely Booker claims. Petitioner claims that his appellate counsel was deficient when he abandoned petitioner's claim. S. Under Blakely v. Washington, 124 seat. 2531, 2004, and Booker v. United States, 125 seat. 738, 2005. More specifically, petitioner contends that his appellate counsel failed to preserve a meritorious Blakely Booker issue by not raising it in his petition for writ of certiorari to the United States Supreme Court. Appellate history and counsel's actions. Ajayan was sentenced by the district court on April 28, 2003. His appeal to the Sixth Circuit was decided on December 15, 2004. On appeal, Ajayan had argued that his sentence was unconstitutional under the Supreme Court's decision in Blakely. The Sixth Circuit disagreed, based on its decision in United States v. Koch, 383 F.3d 436, 6th Sir. 2004, which held that the sentencing guidelines were not invalidated by Blakely. Petitioner then filed a petition for writ of certiorari in the United States Supreme Court, but the petition did not explicitly raise his Blakely issue, and the petition was denied. Jolson and Stover rulings. A defendant who wants to testify can reject defense counsel's advice to the contrary by insisting on testifying, communicating with the trial court, or discharging counsel. Jolson, 7F.3d at 177. At the core, a defendant must alert the trial court that they desire to testify, or if disagreement with disagreeing, whether they should take the stand. Pelser v. United States 105 F.3d 659, Table 1997, WL 1125, et 2, 6th Sir. Jan. 13, 1997, unpublished. When a defendant does not alert the trial court of a disagreement, waiver of the right to testify may be inferred from the defendant's conduct. Waiver is presumed from the defendant's failure to testify or notify the trial court of the desire to do so. Jolson, 7F.3d at 177. Stover, 474 F.3d at 908. 09, citing Weber, 200 F.3d at 551. This issue is controlled by the Sixth Circuit's holdings in Stover and Weber. Because Agin did nothing to alert the trial court to his desire to testify, and because the trial court was under no duty to inquire, the district court correctly presumed that defendant Agin waived his right to testify. Agin did nothing before the conclusion of G. Issue VI, Yak, Blakely Booker claims, continued. Petitioner claims that his appellate counsel was deficient when he abandoned petitioner's claim, S, under Blakely v. Washington, 124S, seat 2531, 2004, and Booker v. United States 125S, seat 738, 2005, Doc. 2, at 25. More specifically, petitioner contends that his appellate counsel failed to preserve a meritorious Blakely-Booker issue by not raising the issue in his petition for writ of certiorari to the United States Supreme Court. Appellate history and counsel's actions continued. Agin was sentenced by the district court on April 28, 2003. His appeal to the Sixth Circuit was decided on December 15, 2004. On appeal, Agin had argued that his sentence was unconstitutional under the Supreme Court's decision in Blakely. The Sixth Circuit disagreed, however, because of its decision in United States viewed. Koch, 383 F.3d 436, 6th Sir, 2004, in bank, which held that the sentencing guidelines were not invalidated by Blakely. Petitioner then filed a petition for writ of certiorari to the United States Supreme Court, which did not explicitly raise his Blakely issue but challenged the district court's fact-finding for the purposes of sentencing Agin as a career offender, citing Blakely. On January 12, 2005, the Supreme Court decided Booker, and on January 24, 2005, Agin's petition was denied. Booker sentencing changes for co-defendants. Petitioner Simpson's petition was granted on February 28, 2005, and his case remanded to the Sixth Circuit for further consideration in light of Booker. Simpson v. United States, 543 U.S. 1182, 2005. On June 13, 2005, Bowers' petition was likewise granted. Bowers v. United States, 544 U.S. 995, 2005. After Bowers and Simpson's cases were remanded to the district court for resentencing, Bowers was sentenced to 156 months of imprisonment, and Simpson was sentenced to 432 months of imprisonment. This represented a reduction from the original pre-Booker sentences for Bowers and Simpson of 55 months and 49 months, respectively. In Ballard, appellate counsel deficiencies. In Ballard, a panel of the Sixth Circuit considered whether a defendant received ineffective assistance of appellate counsel due to the failure of her attorney to raise issues related to Apprendi v. New Jersey, 530 U.S. 466, 2000, and United States v. Dale, 178 F.3d 429, 6th Sir. 1999, on direct appeal. While neither Apprendi nor Dale had been decided at the time of Ballard's trial, both were decided while Ballard's case was on direct appeal. Government response on appellate waiver. The Sixth Circuit, while noting that it is not required for attorneys to foresee changes in the law, nevertheless found that, once an important and relevant change does come about, we do expect counsel to be aware of it. Ballard, 430 F.3d at 408, citing Johnson v. United States, 520 U.S. 461, 468, 1997. The Sixth Circuit held. applying a plain error standard of review, that appellate counsel prejudices a client when the attorney fails to raise a meritorious claim on direct appeal where the error would have altered the outcome of the appeal. Id. At 409. Burgess case appellate waiver. The government directs the court's attention to the Sixth Circuit's unreported decision in United States v. Burgess 142 F. App Ex 232, 6th Sir, 2005. Burgess was convicted in the district court and sentenced under the mandatory guidelines scheme pursuant to a plea agreement which included a waiver of his right to take a direct appeal. In an attempt to evade the appellate waiver, Burgess argued on direct appeal that he did not enter the plea agreement knowingly, voluntarily, and intelligently, and that the district court failed to comply with the requirements of federal rule. A different panel of the Sixth Circuit just this past year considered a factual scenario more closely akin to Ajans than either Ballard or Burgess. In Nichols v. United States 501 F.3d 542, 6th Sir, 2008, Reed G. and Bank granted, opinion vacated January 3, 2008. The defendant and a co-defendant were convicted in 2002 on bank extortion and firearm charges, and Nichols was sentenced to 405 months imprisonment under the mandatory sentencing guidelines. Nichols appealed but challenged only the district court's jury instructions. Nichols' conviction was affirmed on direct appeal and no petition for writ of certiorari was filed. His co-defendant, however, did petition for certiorari, arguing that his sentence was improper because of Blakely. On January 12, 2005, the Supreme Court decided Booker, and the co-defendant's petition for certiorari was granted, and his case remanded for resentencing. The co-defendant ultimately received a sentence 9 months less than his pre-Booker sentence. Nichols then filed a motion to vacate his conviction and sentence pursuant to 28 U.S.C. S. 2255. He argued that he received constitutionally ineffective assistance of counsel because his attorney failed to argue that mandatory guidelines violated the Sixth Amendment based on Apprendi. The panel held that adequate counsel would have filed a petition for writ of certiorari to preserve the Sixth Amendment challenge on appeal and found prejudice to Nichols in the experience of his co-defendant, who received a sentence 9 months less than his original sentence on remand. Because the issue in Nichols is very similar to the issue raised by Ijan, this court deferred ruling on Ajan's claim until the en-banc Sixth Circuit rendered a decision, which it did on April 29, 2009. The en-banc opinion forecloses Ajan's argument that his appellate counsel was constitutionally ineffective in failing to preserve the Booker issue in the petition for writ of certiorari. Judge Batchelder, writing for an 115 majority of the full court, declined to address the broader constitutional question of whether a criminal defense attorney is ineffective by failing to preserve a future change in the law argument in the hope that the Supreme Court will strike down the existing law, while that defendant's case is still pending on direct appeal, and found that because defendants are not constitutionally entitled to the assistance of counsel in preparing petitions for certiorari, Nichols could not have been prejudiced by the failure of appellate counsel to file a petition for certiorari. Inability to receive the benefit of Booker, the benefit that co-defendants, Simpson and Bowers, did receive in the form of a post-Booker resentencing and a sentencing reduction. At 251, he can likewise establish no prejudice, because even though his co-defendants were successful in achieving a remand of their cases for resentencing after Booker, that is not dispositive and improperly turn on the type of hindsight discouraged by Strickland. Id. At 252 Fen. 8. Quoting Range v. United States 25 F.3d 1049, Table 1994 W. Lel 252,643, at 4, 6th Sir. June 9, 1994. This issue, therefore, lacks merit. Motion to supplement. On April 23, 2009, more than 3 years after the filing of HSS S-2255 petition, and more than 4 years after the denial of his petition for certiorari by the Supreme Court, Ijan has filed a motion to supplement his SS-2255 petition. That motion, Doc. 336, is denied as untimely. The Anti-Terrorism and Effective Death Penalty Act of 1996 established a 1-year statute of limitations for motions to vacate, set aside, or correct sentence pursuant to 28 U.S.C. SS 2255. The limitation period for the filing of a SS 2255 petition by Ijan began to run when his judgment of conviction became final on January 24, 2005, the date the United States Supreme Court denied his petition for writ of certiorari. 7. The original SS 2255 motion was timely filed. The motion to supplement is untimely unless it falls within the exception of 28 U.S.C. SS 2255 F4, which provides that the one-year statute of limitations begins to run on the date on which the facts supporting the claim or claims presented could have been discovered through the exercise of due diligence, or because the attempted amendment relates back to the original filing. Ojan's motion to supplement contains an allegation that the United States District Judge, who presided over his trial, now deceased, was suffering from Alzheimer's disease at the time of the trial. Ojan claims he was apprised of that fact by his appellate attorney, who professed a belief that the trial judge should not have been presiding over the criminal trial due to suffering from Alzheimer's. Doc. 336 at 1. He further claims that his appellate attorney told him the issue could not be raised as an issue in the petitioner's direct appeal because the judge was too well respected. Ijan cannot show, therefore, that he has exercised due diligence in the presentation of his claim and offers no explanation for his delay of more than 4 years in the filing of his claim. Ojan's filing, likewise, does not relate back, thereby allowing him to escape the one-year time limit. In 2005, the Supreme Court very significantly restricted application of Federal Rule of Civil Procedure 15, C2, in the SS 2255 context when it held that a claim in an amended petition does not relate back to the original date of filing under Rule 15, C2, when it asserts a new ground for relief supported by facts that differ in both time and type from those set forth in the original pleading. Ojan has cobbled together a collection of hearsay, supposition, and fanciful visions of conspiracy between the Assistant United States Attorney, who tried the case, the federal and state law enforcement officers involved in the case, and the trial judge, to support his argument. Because he did not raise the issue before the trial court or on appeal, he has procedurally defaulted the claim, even if it were timely, and he must show both cause and prejudice for his failure to raise the claim. The only argument Ojan makes to potentially excuse his failure to raise the issue before the trial court or on direct appeal is that his appointed attorney advised him that he could not be successful on appeal because the trial judge was too well respected. He also argues, unpersuasively, that he had no confirmation of the trial judge's disability until he heard news reports of the judge's death on July 31, 2008, following Alzheimer's disease. These allegations do not establish cause for his failure to raise the claim earlier. Ojan clearly knew of the claim while his case was still pending in the trial court, and a review of the more than 150-page motion to supplement and attached exhibits clearly reveals that his attorney's advice not to raise the issue on direct appeal was sound advice and falls far short of raising a claim of constitutional magnitude. It is also significant that Ojan does not characterize his appellate attorney's advice as deficient and identifies no acts or omissions of counsel that are alleged not to have been the result of reasonable professional judgment. Strickland, 466 U.S. at 690. Nor can he show any prejudice from counsel's performance on this issue. An error by counsel, even if professionally unreasonable, does not warrant setting aside the judgment of a criminal proceeding if the error had no effect on the judgment. I'd at 691. Even accepting all of Ojan's allegations as true, those allegations do not support the conclusion he draws. For instance, Ojan points to the fact that the trial judge took senior status on October 1, 2002, as evidence that he should not have presided over Ojan's trial, which began on December 17, 2002, and that since no explanation was ever offered, the trial judge's senior status must necessarily have been related somehow to some sort of disability. No such conclusion can be drawn. 28 U.S.C. SS 371 authorizes a district court judge to take senior status whenever the judge's years of service and age total 80 and the judge is at least 65 years of age. Disability is not a prerequisite to senior status. No error in the trial judge's rulings or behavior during the trial, Even if there were some technical error in some of the trial judge's rulings and actions, those errors were, without doubt, harmless, and there is no doubt that absent the alleged errors, the result would have been the same. The sole remaining claim, count 10, non-existent offense. Count 10 of the indictment charged Agin with a violation of Title 18 U.S.C. SS 924 C.1 as follows. The grand jury charges that on or about December 9, 2000, in the Eastern District of Tennessee and elsewhere, the defendants, Alan Mark Agin, George Hubert Simpson, and Vance Bowers, aided and abetted by each other, did knowingly and intentionally possess a firearm during and in relation to a crime of violence, to wit, the kidnapping of Ernest White, Ricky Howe, and Curtis McDavid. Section 924, C.1, makes it a crime offense for any person who, during and in relation to any crime of violence or drug trafficking crime, for which the person may be prosecuted in a court of the United States, uses or carries a firearm, or who, in furtherance of any such crime, possesses a firearm, 18 U.S.C. SS 924, C1, A. Agin now contends that, as a consequence of intervening change in law in the circuit, that count 10 of the second superseding indictment must be dismissed. More specifically, Agin contends that count 10 fails to charge him with a federal offense, and that the court, therefore, lacked subject matter jurisdiction as to count 10 in light of the Sixth Circuit's intervening decision in United States v. Combs 369 F. 3D 925 6th Sir. 2004. In Combs, the defendant was charged and convicted of 2 SS 924 C violations. One of the counts charged Combs with possession of firearms in furtherance of a drug trafficking crime, and the other charged that Combs possessed a firearm during and in relation to a drug trafficking crime. In reversing both convictions, the Sixth Circuit held that SS 924 C criminalizes two distinct offenses: 1. Using or carrying a firearm during and in relation to a drug trafficking crime, and 2. Possessing a firearm in furtherance of a drug trafficking crime. Combs 369 F.3d at 931. Citing Bailey v. of United States 516 U.S. 137, 143, 1995, the court noted that use of a firearm connotes more than mere possession of a firearm and requires some active employment of the firearm by the defendant. I'd at 932, quoting Bailey, 516 U.S. at 143. To carry a firearm means the firearm must be on the person, as when a person knowingly possesses and conveys firearms in a vehicle, including in the locked glove compartment or trunk of a car. The Sixth Circuit has determined that, for a carrying offense, the firearm need not be immediately available for use, and that the proper inquiry, in determining whether a firearm is being carried, is physical transportation of the firearm. Ed. at 933, citing Hillard v. United States 157 F3D 444, 449, 6th Sir. 1998. The during and in relation to element requires that the firearm furthered the purpose or effect of the crime, and its presence or involvement was not the result of coincidence. I'd, quoting United States v. Warwick 167 F.3D 965, 971 6th Sir. 1999. The indictment in this case, as in Combs, charged the defendant with possessing a firearm during and in relation to a crime of violence, utilizing one element from each of the two distinct SS 924C offenses. This, as the Sixth Circuit found, resulted in the defendant not being charged with any codified federal crime. Thus, had Agin or his co-defendants raised this issue on direct appeal, the claim would have resulted, as it did in Combs, with reversal and remand for a new trial on the SS 924C charge. While seeming to acknowledge that Agin's argument would have had merit if it had been raised on direct appeal, the government argues that, because it was not raised on direct appeal, the claim has been procedurally defaulted. A claim is procedurally defaulted when it is raised for the first time on collateral review, and no contemporaneous objection was made, nor was the issue raised on direct appeal. United States v. Frady 456 U.S. 152, 167, 68, 1982. Where a petitioner has procedurally defaulted a claim by failing to raise it on direct review, the claim may be raised in a motion under S-2255 only if the petitioner first demonstrates either cause for the default, an actual prejudice, or that he is actually innocent. Bosley v. United States 523 U.S. 614, 622, 1998. The government argues, therefore, that agent must show actual prejudice before he can prevail in this SS-2255 proceeding, and the government may be correct. However, agent, on the other hand, citing United States v. Adesida 129 F.3d 846, 6th Sir. 1997, contends that he has not procedurally defaulted his com's claim, even though the argument was not raised on direct appeal. In short, he argues that, because the indictment did not charge a cognizable federal offense in Count 10, the district court lacked subject matter jurisdiction to try him for the alleged violation of the law. He argues that lack of subject matter jurisdiction may be raised at any time, including during a proceeding under 28 U.S.C. SS 2255, citing United States v. Adekoya 92F.3d 524, 527, 6th Sir. 1996.
All right, so we got through it. 2 hours, 11 minutes, not bad. I don't have to cover it again tomorrow. All right, so I think what I'm going to do is jump off. I'm going to take the rest of the night to concentrate on some other stuff and put it together for tomorrow. I'll do 1 or 2 lives tomorrow. We'll see what I'm putting together tonight. It's going to take me some time. I think what we'll do is we'll go over each of the... It ain't like the whole indictment that I found. It's from a Tennessee law. You'll see. I'll show you the website I find it on so you guys can look at it yourself. But I want to show you some of where these people come from without using names, if that makes sense. Because I think it's important. It could be Elaine into Summer's case. Could be why Squall has jumped into this. I really wish she'd grab a link. But, yeah. That's where we're at. So I'm going to take the rest of the night off to spend it with my hubby. Thank you guys all for being here and listening. Sorry I cut the prayer garden stuff off, but I thought this was a little more important, and we're still getting to the prayer garden stuff because I think that's important too. And Andrew, I'll try to come live early tomorrow. I'd really like you to grab a link and talk about some of the Jeremy stuff that Allie spoke about with Prayer Garden. I'll take Prayer Garden out of it and we'll just listen to what I edited. If that's okay. We don't have to listen to all her commentary. We already know it's freaking gross lies and chaos out of her mouth. No, thank you for being here, Cotton Candy. All right, guys. I'll see you tomorrow. I'm going to go finish my dinner with my hubby. I was stuffing my face before that ended. The food came at the wrong time. I'll see you tomorrow. Good night. Peace and love.